Good afternoon and welcome. My name is Thomas Bona. I'm a partner at Pillinger Miller Tarallo, and I'm the moderator today for our conference webinar. Today is our fourth Pillinger Miller Tarallo, St. John's Tobin College of Business, Greenberg School of Risk Management Conference Series webinar. And our focus here is to provide provocative ideas, important and current issues, and examine them with thought leaders and industry experts. And we're so very grateful and thankful for our partnership with St. John's Tobin College of Business. I'd like to first thank Dean Norianne Sharp, who is the Dean of the Tobin College of Business, for all her help and support with our conference webinar series. I'd also like to thank Dean Brandon Schweitzer, who's the Dean of the Greenberg School of Risk Management. And of course, Larry Pistel, who helps us behind the scenes, making sure that this functions smoothly. And we've got a great topic today. After nuclear verdicts, time to exit the fallout shelter and try cases. It's a topic that's out there in our literature. It's a topic that people are talking about, and it's a topic that doesn't seem to want to go away. So we're going to discuss what that's all about. And we're also going to take a look at what some solutions could be to this. And we have a great panel. We've got a great panel of industry experts and thought leaders. And so I'd like to start off by taking our panel and asking them to introduce themselves and say a few words about themselves. First, Jeff Miller, would you please introduce yourself?
Good afternoon, everybody. Jeffrey Miller with Pillinger Miller Tarallo. I'm one of the founding members of the firm, and thank you for your time and attention.
Jeff Schulman, would you please say a few words?
Yes, good afternoon, Jeffrey Schulman. I run the upstate offices for Pillinger Miller Tarallo and been working with Jeff Miller, Mark Pillinger, and Nick Tarallo for, 30 years together. So long time.
Thank you, Jeff. Ernie Barnaby, could you please tell us a little bit about yourself, please?
Yes, I'm Ernest Bernabe. I'm the managing partner of the Philadelphia office. I've tried probably in excess of 250 cases to verdict in Pennsylvania, New Jersey, and Pro Hoc Vice in all areas involving construction, premises liability products, runs the gamut, professional liability. I'm very pleased to be here today.
Thanks, Ernie. Jeff Block, would you please tell us a little bit about yourself?
Third time's a charm. There's 3 Jeffs on this panel.
Right.
Jeffrey Block from Block, O'Toole and Murphy. I'm the founding partner. Started the firm in 1989. And as I discussed with this panel beforehand, I am the problem. And the problem is we talk about nuclear verdicts. My firm is responsible for publishing more 7-figure resolutions than any firm in the state of New York. 13 years running.
Thanks, Jeff. And we're going to be talking about that at some length today. So thank you so much. Now, let me introduce Professor Albert Beer from the Greenberg School of Risk Management, the Tobin College of Business. Professor?
Thank you, Tom. After a 35-year career in the insurance and reinsurance business, I had a number of positions, including chief actuary, executive VP, and ended my career as president of Munich Re America. I had the distinct pleasure of joining the faculty of St. John's 15 years ago. So the last 15 years, I've been doing that, serving on a number of insurance company boards and giving presentations throughout the insurance industry.
Thank you, Professor. And Professor Jack Jennings, would you please tell us a little bit about yourself?
I'm Jack Jennings. I am here in my role as an adjunct professor at St. John's University Greenberg School of Risk Management, but I am also an insurance broker. I'm an executive vice president with Willis Towers Watson, and that's where I am now in a 45-year career in insurance brokerage and corporate risk management.
Thank you, Professor. And finally, Anthony Coleman. Anthony, please tell us a little bit about your background.
Oh, thank you, Tom. My name is Anthony Coleman. I'm the Vice President of Tradesman Program Managers, and I've been managing claims and trials in New York State in complex matters for the last 25 years.
Thank you, Anthony. So as you see, we've got a really terrific, high-level, high-power panel to talk about nuclear verdicts, runaway verdicts, social inflation, and we're very happy at Pillinger Miller Tarallo to serve as your trusted advisor and to get this information out to our industry because we feel it's important to raise these issues and talk about them. So let's dig in. Let's start. Professor Beer, you've served as president of Munich Re. You've also served on 4 boards. You're an actuary. You are in the C-suite and you hear what goes on, the discussions. Tell me, how much of a threat to the insurance industry are nuclear verdicts, runaway verdicts, and social inflation?
Well, let me start the discussion with a general observation, first of all. I think it's helpful to recognize that nuclear verdicts are just a direct byproduct of the existence of a number of complex factors that generally are categorized as social inflation. I'm sure we'll be discussing that over time. But first let me be clear. Jeffrey, I am also part of the problem. There is not a board of insurance company or a management team today that doesn't meet and have an exhausting discussion of social inflation and the effect on the financial strength of the company. But that's the major problem. These companies spend virtually all their time, in my opinion, and again, I'm part of the problem, reactively checking to see if these additional costs are part of the pricing or reserving models. As opposed to discussing ways to mitigate these factors that cause social inflation and ultimately nuclear verdicts. So let's talk a little bit about some of those factors. I'd like to just throw them out to get the discussion started. First, let's acknowledge, all right, the decisions of today's judges and juries clearly represent or typify the emotional frustration we have with economic and social justice issues. That's clearly affecting a lot of decisions. But to be fair, in my opinion, the plaintiff's bar has read the room much more effectively than the insurance industry. I hate to invoke a contemporary metaphor, but unfortunately, I think based on some of the strategies that a lot of our insurance industries and professionals have been using for years, I get the impression that many insurance claims people feel that they're forced to play Wordle, and the plaintiff's bar is solving the New York Times crossword puzzle. I think there's an issue where we've got to up our game significantly. Defense counsel can dismiss as distasteful, plaintiff strategies such as reptile theory. I'd like everyone to ask themselves, isn't it typical that a defense witness, the key defense witness, is a scientist going through expert testimony, and the key plaintiff witness is a widow describing how she's going to raise 3 kids as a single mother? I think we need to recognize mores and society is changing, and we've got to be able to change with it. Traditional defensive strategies struggle against a plaintiff bar that, in my opinion, is weaponized social media, has raised an estimated $17 billion worldwide for third-party funding litigation.
Thank you, Professor. Yes, continue, please. No, that's a tremendous insight, and that's one of the areas that we're going to, of course, get into, because there is a theory, and people say that, while the plaintiff's bar has been much better able to organize and use various principles, the defense bar has been very slow to react. So we have 3 great defense attorneys on our panel today. We've got Jeff Miller, who is one of the founders and executive partners of Pillinger Miller Tarallo. We've got Jeff Schulman, who is also an executive partner and managing partner of the firm's upstate offices. We've got Ernest Barnaby, who is the managing partner for the Philadelphia and the New Jersey offices. Let me ask the defense attorneys first. Were nuclear verdicts an accident waiting to happen, or should we have anticipated this? Jeff Miller, Jeff Schulman, Ernie, want to step on this one?
Okay. I think we all saw it coming. I've been practicing now, 30-something years, and those $400,000, $500,000 cases used to be big cases. And the $1 million case was a rare exception, the 7-figure case. And we just saw it kept on going up and up and up. And like Jeff Block had mentioned, they prepare these cases. I've gone into mediations with Block O'Toole, and they have all the experts. They give you the material before you're there, and they're blackboarding significant 7-figure, 8-figure numbers, whether it's on economic loss and or future medical care. Jeff mentioned something earlier about, publishing the most, the 7-figure, 8-figure verdicts. I will tell you, many of those 7 and 8-figure numbers are settlements, and they're only going to be settlements with PMT. And the reason is, and this will be part of this program, is we know this business and we help you manage risk. And the best case is a settled case, and reasonable minds can have some disagreement within a certain range, but it's a lot different than a plaintiff-oriented venue is usually going to award plaintiff's counsel in these cases that we're dealing with. So I think we should have seen it coming and should have been more prepared.
Okay.
No,
Let
and
me
I'll
ask-
add,
Yeah,
Tom,
Jeff, please.
I'll add,
please.
I don't see it as a recent trend. I started with Jeff Miller a long time ago in the early 90s doing defense work, but then I went for about 5 years and worked at a plaintiff's firm. And we saw a fairly decent amount of 7-figure verdicts, and we started to take 8-figure verdicts when we could blackboard on construction cases and labor law cases, the numbers to justify the verdict. So it's not a new trend or a recent trend. It's getting worse, certainly. And I think we've yet to see the impact of COVID and whether there is a pent up frustration that's going to be, matted out by the juries as we start taking significant verdicts and trials begin to really move forward as they have been and move forward fairly frequently now. So it's interesting. I think literally the jury's out on how significantly the impact of COVID will be on runaway or nuclear verdicts.
Yeah, thanks, Jeff. Ernie, you've tried over 300 cases. Same impression?
Well, yeah,
You see
so
the same thing?
I'm the gunslinger in the defense crowd here, right? I try a lot of cases, but I'm not a fool. And obviously most cases that I have settle, and it's a matter of setting the strategy and early on. I mean, you have to recognize early on the cases that are going to be problem cases, for different reasons, but, a well-prepared case where the numbers are going to be put on it and so forth and so on. So I think a lot of this is cyclical in terms of the types of cases where there have been big verdicts. When I tried a large volume of med mal cases in the 90s for various, when FICO went under and other carriers went under, and I took over for the guarantee fund, and I was trying a med mal case every couple of weeks. And they were these massive med mal verdicts. There were $100 million verdicts and so forth. That's waned to some extent, and that's in Philadelphia mostly, and in Pennsylvania. New Jersey a little bit different. But then there's other things that come up, and you see them, and the plaintiff's bar is aware of this. You see major construction cases and other types of cases. You see different types of mass tort actions and so forth. So a lot of it is cyclical. But that being said, I do think that the jury literally is still out on a lot of this to see how juries react. And yeah, the numbers keep going up. Part of that's inflation, the cost of living, and so forth. But I also tend to believe that a lot of juries understand to some extent that there's a certain amount of money available and it's not endless. And so they will award the numbers on the right cases, and they'll be skeptical as to the wrong cases. So what I'm saying is there's still defense verdicts out there, but those are just my general thoughts.
Thank you. Thank you, Ernie. Let me turn to Jeff Block, our plaintiff attorney, one of the most renowned plaintiff attorneys in New York and probably nationally. Jeff, give us your perspective. Is this something that just happened, or was it just something that was just happening over time as damage awards got larger and larger?
Well, I agree with all the panelists so far. Jeff mentioned that it's something that's gone on, but not to be surprised about. Ernie's mentioned the fact that there are juries get it right. I think juries do get it right generally. It's hard to sit back and say what a jury would do or would not do, but as Jeff Miller said, the best case is a settled case. And we often find cases where there are large verdicts because the defense turns around and takes a position that's unreasonable. So if you put us where we have no other choice but to take a verdict, we'll take the verdict. If a case is properly evaluated on both sides, case should be resolved. And if you have a case that's worth X dollars and someone offers you, 80, 90% of X, you've got to bring it to your client. The problem is when they offer you 5% of X, and you're forced to take a verdict.
Let me ask a question for the trial attorney. So you probably have 500, 700, 800 cases tried amongst you. So you've had a lot of experience with juries and you've seen the juries. Are juries angrier and meaner, quote unquote, than they were, say, 20 years ago? Is this just a function of the lack of civility that's generally in society and the coarseness of society nowadays? What do our trial attorneys have to say about that? Because that's a factor. Jurors who are angry, jurors who are dissatisfied, jurors who feel marginalized, they're likely to give more money than if they were, reasonably accommodated and say conservative. Who wants to start with that one?
Hopefully not the juries that I pick.
And I was going to say that,
So much
Ernie, because I think you want to flush out that anger during jury selection, right? If you think a juror, prospective juror, is an axe to grind, and you can't flush that out during jury selection, I don't think you're doing your job asking the right questions and connecting with the prospective jurors. But Ernie, sorry to interrupt. You really triggered that.
I know. I really don't find that if you do a decent amount of screening of the juries that there's that much anger involved, and it can work both ways too. I mean, I've had cases where, I have had people, I've intentionally allowed people to be on my jury who had cases when I have a really questionable plaintiff's case where they've had cases where they've gotten recoveries and they view it as saying, hey, this particular plaintiff is really trying to take advantage of the system. And when I was a plaintiff, I didn't. And, they can be angry at the plaintiffs for that, for overreaching. So you could see that as well. You see people taking advantage of the system, and I think juries can pick up on that. So I don't, it can cut both ways. Really, it can.
Okay.
Yeah. And Tom, we have a question from Carolyn Solo, and it's similar to what we're talking about. It says, do you think people are just angry in general as an aftermath to the pandemic? And I think that's important to touch on because I don't think, again, we really know yet. I will tell you that typically the courts are extremely accommodating to the jurors to make them feel as comfortable and as important as they should feel because they're doing a civic service and a civic duty. We tried, we ended up settling, but we picked a jury very early on in September 2020, and they didn't have the systems set up to accommodate the jurors. And this was in Onondaga County. It was just, a terrible setup, and they relied too much on the attorneys to get it right. And I could see in that context, and plaintiff could as well. So to Ernie's point, it could cut both ways. I could see that the jurors were not pleased to be there. And, that could cause some backlash, and that was directly pandemic related.
Good. Let me get the plaintiff's perspective. Jeff Block, what do you feel? Do you think that jurors are angrier? Are they more disenfranchised than they were 15, 20 years ago? What's your perspective on that, Jeff?
This is like a typical trial. I have 3 defense guys on one side, and I'm being asked questions.
You're getting ganged up.
I think people in general are a little bit disenfranchised. Yes, I think it's important, as Jeff had said and Ernie had said, that you have to flush this out during jury selection. You want to get what people are really thinking about and how they feel about the system, how they feel about sitting on this particular case, and what their attitudes are. If you don't flush it out, shame on you.
Okay, that's a fair answer and a good answer. Let me go back to something that Ernie touched upon about the cyclical nature of damage awards. Back 15, 20 years ago, all the high med mal awards, there were certain things that were put into place to try and reduce those verdicts. Let me ask Professor Beer, because you've studied this and you've looked at this from the actuarial standpoint. Are these things cyclical in nature? In other words, verdicts go up, verdicts go down, damages go up, damages go down. Do you see that from an actuarial standpoint?
There's definitely been a history of cyclicality in the industry on several levels. Clearly, the 70s and 80s, many people may recognize, for example, tort reform was a big issue there. So one of the ways in which cyclicality can be introduced is the advent of some type of tort reform. I wouldn't necessarily say cyclicality in the sense that it's predictable. It's not as if it's a sine wave per se, but I would definitely say there's ebbs and flows. No doubt, I think there's economic factors that have a lot to do with it. I think 2008 and the financial crisis probably had some influences in coming out of that. When we talk about social issues, reviver statutes, I'm sure everyone on this board cringes when we start thinking of that particular issue. So it's not as if there's this natural ebb and flow. I think there's exogenous factors that enter into it, but there's no doubt that it does have certain types of cyclicality to it. And I don't think we should look at it as, an exponential, continual exponential rise of increase.
Thank you, Professor. Let me turn the next question over to Anthony Coleman. Anthony, you are the Senior Vice President and you are with Tradesman Program, a construction book of business. You've been involved in the construction industry for many years. You've seen a lot of those cases. And as we know, those cases can have big exposure. They're usually bad injuries. People have lost earnings, lost, damages in perhaps the millions of dollars just to start with, future care, loss of earnings, loss of enjoyment of life. But those are the big cases. And there's a school of thought within the industry that's examining nuclear verdicts and, this whole concept of social inflation is that, cases need to be better prepared. Cases need to be, much more aggressively defended, starting from, say, the filing of an answer. But from the inside, from the claims perspective, let me ask you this. Is it reasonable to prepare every accident case as a potential nuclear case, Armageddon? And will insurance companies even pay for that, given loss adjusting expenses and all the things that they do to take a look and control their expenses? What do you see?
Thanks, Tom. That's a very, very good question. I think you have to look at every case, one by one, because if you just take this broad brush and you look at every case and you think every case that comes through the door is going to be the worst case that you have, it's just not fiscally responsible. I know one at Panelists is an actuary, and you start seeing, if it comes to seeing those expense numbers, go up, that's not going to be helpful either. So you have to look at every case and decide what that case needs. You have to look at the case. What's the fact pattern? Who's our adversary? How bad are the damages? And then make your decisions based on that, on how much you want to invest into those cases. But to go off on a slight tangent, one of the things I think is important is what Jeff Block had brought up. I think when you have a case, the most important thing that you could do to avoid a nuclear verdict is properly evaluate that case, look at that case, because usually reasonable minds will be in a certain range on cases. So if you look at a case and you put a fair value on it, I think that's going to help you. I think the ADR process is certainly important as well to kind of help you resolve cases. And if you have to try cases, things to think about too, to avoid nuclear verdicts, or think about high lows, think about bifurcating a case. You have to think about conceding liability when that's appropriate to help you with the nuclear verdict. So I think those things are what claim departments are kind of thinking about to avoid those nuclear verdicts.
Tom, can I just jump onto the end of that?
Sure, Jeff, hop right in.
Anthony, one of the things you started mentioning, which I think is really important, is this ADR. And oftentimes we'll go to mediation and we'll find that our quote adversary and the adversarial team is very adversarial. And if you want to talk about a breakdown of communications, have someone go in there and insult you or insult your client. It's not an effective methodology of communication, and communication is key. So if we want to resolve cases, I think everyone has to be open-minded. Like, I have a case with Jeff Miller or with Mark Pillinger. The first thing we do is we get on the phone with one another. Anything you need, you can have. He'll ask me, like Jeff will say to me, where do you see the case going? And no matter what I say, he'll say to me, that's ridiculous. But at the end of the day, he'll at least ask me, how do you get there, and why do you think you should go there? And we'll talk the case through, and oftentimes we'll find a happy point of resolution without having to take a verdict.
Jeff,
And
let me,
I
yeah,
agree
go ahead.
with that. Just, I won't belabor, I'll be quick, Tom.
No.
Jeff, you're correct. I mean, I think any situation, where, I'm, saying negative things about your client, or about the attorney involved, it's not going to lead to any productive conversation at all. So, I mean, I think you're correct. I mean, I think the first thing is to communicate with people, talk to people, and I think too, if people have an offer, try to give, try to explain how you got to that number. Here's how I got to this number. I question this portion of your damages. I question this on the liability end. So at least you have some perspective on where I'm coming from, and I'm not just pulling numbers out of the sky. I'm actually, giving you my thought process behind how we got somewhere, and trying to be transparent with you as we try to move the case forward.
And that's smart, and that's going to get a case to a point where people will have a dialogue, and eventually the case will have an opportunity to be resolved.
I mean,
No question.
obviously, yes, question,
No
Jeff.
question. I'm saying no question. And there are two questions out there. But in regards to what Jeff and Anthony and all of us have been talking about, we prepare these cases as if they're going to go to trial, because that's how we're going to get our best number with the Block and O'Toole's out there. We can't go in not prepared. You don't want to be caught short without your experts. So everybody understands, and I say this all the time, we're in the resolution business. We're managing risk. That's what we're doing with our clients and our teams. It's so important. I had interns for Judge Donson a million years ago, and his favorite saying was, you don't know what 6 clowns in the box are going to do. You want 6 clowns to decide this case, or do you want to get rid of this case? It's the Tony Montana famous, I know the game, Mel, you go high, I go low. It's the importance of starting those negotiations early on. We collaborate. Jeff Block and with many attorneys in this office, we have each other's cell phones. We work together. As much as something has occurred and we're on 2 separate sides of the litigation, it doesn't mean it has to be adversarial. We're both looking to resolve the case, and the quicker we start that negotiation, the quicker we start talking about it, the quicker that gap is going to close, and he's not going to be forced to try the case, and we're not going to be forced to try the case, because the differences that we're talking about are here now rather than here and here, where they're just, that's what forces the trials.
Great,
So-
great insight. Thank you.
Tom, we've got some questions. I don't know if you want me to read a few
Yeah,
off.
let's take them. Sure.
Okay, so we've got a few, and I'm
let's
gonna
attack
start
them.
with, yeah, William Wilt sent a question, and this actually relates to one of our prior webinars that we did regarding COVID. And the question is, did the pandemic accelerate the settlement of smaller and less contentious claims? That's his first question. And then related, how have plaintiffs' attorneys been holding back their more complex and higher valued claims, waiting for courts to reopen before trying them? We've answered this question before in our prior
Right.
webinar, but we didn't have the benefit of Jeff Block sitting with us, which really can provide some terrific perspective. So I'm going to ask Jeff Block to answer that question, and then everyone else can weigh in.
Well, thanks, Jeff. Interestingly, our business is mostly referral work from other members of the bar. So other plaintiffs' firms seek us out on their most valuable cases. And that's because they don't have the knowledge, time, or money to properly run the case. And if they need, they're not funded properly, the firm needs money to operate, they'll settle the case for less than full value. We will never do that. So they come to us for their inventory, and as a result of the pandemic, we've expanded our inventory tremendously. So when the courts open up, it's going to be, as I always say, like, shooting pigs in the bathtub. You can't miss it. They're right there. But at the end of the day, I think it behooves everyone to try to be reasonable on every single case. If you're reasonable, cases will resolve.
And of course, if people are civil to each other, that helps in the process. So do you think the current, say, going mano a mano, plaintiffs' attorneys against defense attorneys, as some have advocated, as a way of combating nuclear verdicts, is that any help at all in this process?
In my opinion, it wouldn't help at all. I think the most important aspect of our business is communication. I don't recall a single case in 33 years that I've tried as a result of a breakdown. I'm sorry, if there's good communication. Every one of them has taken place as a result of someone doing something that stepped on my toes, on my firm's toes. And I'll give you a quick little anecdotal story.
Please.
Many years ago, I had a trial in Kings County, and it was before the Graves Amendment. So we all know what that was. There was unlimited insurance on rented vehicles. So it was a 3-car accident. One of the vehicles was LRAC Rent-A-Car, and that was the target. If I got 1% against that vehicle, I hit the gold mine. I could collect everything from that particular carrier. The other 2 vehicles were yellow taxi cabs insured by American Transit Insurance Company, which I never deal with. So we did a high-low on the liability. We took a $250 if I got 0 liability against LRAC, and $1 million if I got 1% or greater. The jury came back with a 70-30 split between the 2 yellow cabs. LRAC was out. They paid me the $250,000. I turned to the 2 American Transit lawyers and I said, "You only have 100 apiece. Just give me the $200,000. I'm done." I lost the case. I mean, for me, it was a loss. It was a $450,000 resolution. $250 I collected in 100 apiece. I thought I lost the case. It was a terrible, terrible day for me. And the guys from American Transit said, "We'll never pay you." I said, "Thank you. That was the greatest news I ever heard." I took a $9.3 million verdict. The aptiv sustained 2.7. I took an assignment. I collected the $250, the $100,000, and then I went after American Transit Insurance Company for bad faith. And they paid me $2.8 million over their policy limits to settle the case. So it ended up being a good day overall.
Yes, one of those days, yes. When you have lemons, you make lemonade, that's for sure.
Yeah. And I'll just comment on that question as well with regard to, settling the smaller ones, the less contentious ones. We did definitely see a wave where the phone rang a lot more in terms of resolving cases because nothing was being scheduled for trial and no one knew when the courts were going to open. But I will say that we didn't settle them for less. No one was bargain hunting. I didn't see it. We paid, the value of the case, and we negotiated our best way out of, the cases that we could shave off of. But I didn't see any plaintiffs' attorneys running, whether they had cash flow issues or not, they were not signaling that to us. I think that they held firm to their values, and now the courts are opening up. So, cases are being tried. So that was our experience. There's an interesting question here that I think Ernie would be great to tackle. And it asks, are there any Commonalities or factors you see in prior cases that can signal the potential for a nuclear verdict in future cases.
Well, what you're really looking for are things that develop during the case, in the sense that you can't just look at things in terms of numbers or the specials and formulas and this kind of thing. You have to spot early on what are the factors that are really going to set the stage for a catastrophic verdict. And some of that is how the plaintiff presents in a deposition. How does your client present? Are there things that, they're going to tell a story, but is it just is it just going to play badly? So the thing, it's the human factor that you need to develop and have a sense for. So, I'm not interested in saying, well, my client said this, this, and this. It's sort of like, how does it play out? How does it look? How does the plaintiff present? Because when it comes to trials, assume the law, it's psychology and presentation. So the commonalities are, there are going to be certain witnesses, maybe your client, maybe the plaintiff, maybe fact witnesses that are going to potentially turn the case either for you or badly. And that's something that you really need to identify early on and make your clients aware of that early on.
Anthony, did you have something that you wanted to add to the question?
Yeah, I was just going to say in regards to the settlement case, from a carrier perspective, we were in a situation where, especially in a construction book, where construction sites were actually shut down. We had less trucks on the road, so we had less claims coming in. So it gave us the chance to look at the aging claims that we had and actually start moving some of those claims along, just because there wasn't new claims coming in for us to address. So it gave us a chance to kind of dive into some old claims, find some wood, and move towards resolving those cases.
Good, thank you. Let me direct the next question to Professor Jack Jennings. Professor Jennings, you're an executive vice president at Willis Towers Watson, and you help companies design and implement risk management programs and solutions. How can companies and insureds protect themselves from social inflation, runaway verdicts, and nuclear verdicts?
Well, let me first say that paying attention to the finer points of claims management offered by your firm and your panel. But since I'm not qualified to wrestle in that space, let me offer another critical observation about the insurance business, kind of along Al Beer's comments that the business is reactive. Despite brokers and insurance companies being in the business of selling insurance, there is scant evidence that of a coordinated effort to get commercial insureds to buy umbrella limits. I did a little research before this panel, and I found pockets of service teams that are aware of social inflation, nuclear verdicts, and push their clients to buy more. But I found in most cases, there is not that push. And in fact, since we've been in a pretty pronounced hard market for the last couple of years, I found a lot of examples of commercial insureds cutting back their umbrella liability limits, which is crazy. It's a violation of one of the core precepts of risk financing, which is self-insured down at the bottom where losses are more predictable and you get the premium savings, and buy insurance up top where it's cheaper. And that doesn't seem to be happening in a coordinated way. And I noticed that you have a lot of insurance industry claims professionals attending this webinar. and I'll point this out because I think they'll be interested. The absence of adequate umbrella liability insurance limits exposes the insurance companies to bad faith. I mean, you know, the mechanism that, you know, there's a settlement opportunity, the insurance company, like I forget, Jeffrey Block mentioned American Transit, or they say, we're not going to settle. And then there's a judgment in excess of limits. And guess what? The broker gets sued for malpractice, and the insurance company gets sued for bad faith for failing to take a valid settlement option.
Yeah, that's a very, very incisive comment there. And let me ask Professor Beer, do you find this to be a shortcoming that there is not a greater push to protect insureds and companies by making excess policies more available or making them more well-known?
You're muted, Al. There you go.
Okay. There's a number of aspects of the industry. There's the distribution and there's the risk-bearing side. As Jack pointed out, the risk-bearing side advocates, obviously, buying higher limits. There's an interesting unintended consequence, of course, of nuclear verdicts, and that is eventually companies moving away from some lines of business that are exposed. So ironically, some of those who need the insurance the most tend to run into problems. Some of you may have seen the Time magazine cover of 1980, where it basically said, America, your insurance is canceled. That's a self-fulfilling prophecy, and the industry has to grapple with that. So I think your question is very valid. I think the industry obviously does not want to discourage the increase in business. But on the other hand, frankly, whether they're overreactive or they're not necessarily dealing with the plaintiff's bar as effective as they should be, they tend to be backing away. Ironically, we're in a hard market, so they're getting decent price for other types of business. So I think in a sense, we have a perfect storm there of companies that are not interested in taking more risk. And yet we have commercial entities that need more insurance. I think that's the responsibility of the insurance industry, as Jack pointed out, to address that particular issue.
Thank you. Thank you.
That's
That's
a
a
question,
yeah.
Tom. Do you want to?
Sure, please. Let's
Okay,
take it.
and this one is interesting. I think it actually triggers an overarching conversation, not just limited to this one issue, but maybe a broader issue. And the question is, Ms. Barker types is, do you think the war in Ukraine and the tragedy that has unfolded will have any impact on how juries view a plaintiff? Maybe they aren't as sympathetic to them. And I think the larger question is, when there's something, you know, significant in the news that shows suffering of a mass amount of people, as we've seen on our television screens every day, people being displaced from their homes by the millions, and bombings, incessant bombings of communities. How does that affect somebody when they're looking at, you know, a plaintiff and viewing their pain and suffering? So I put that to anyone in the group if they want to take a stab at that one.
Let me ask Jeff Block, because he's the one who picks the jury for the person who's seeking the recovery. What do you find? Have you seen this kind of a phenomenon? Not necessarily now, because we're just a month into the Ukrainian crisis, but in the past, what's been your experience with this, Jeff?
If you're going to argue, ouch, my back hurts from a soft tissue injury, I think you're in trouble, right, Ernie?
Absolutely. That's exactly the point. I mean, if you're if a plaintiff is clearly overreaching, and I doubt that Jeff has these kind of clients, they're going to be punished.
You know, one of the things that, as Ernie pointed out earlier, is kind of likability and believability. It's like any other aspect of our lives. Jack, if you go into the deli to get a cup of coffee and the clerk behind the counter is not very friendly to you, chances are you won't return. All right, Al, if you walk into the deli and the clerk is very friendly to you and said, sir, I have your coffee the way you like it. I remember you coming in yesterday and the day before, and with a nice big smile on his or her face, you'll smile back and you'll say, gee, that person was fantastic, right? So jurors are really no different. If they like you and believe you, they're going to help you. If they don't like you and don't believe you, you're going to feel their wrath. And jurors aren't foolish. They're intelligent people, and as a group, they have 12 ears, 12 eyes, and 6 brains. They're going to be able to figure it out pretty quickly. So if it looks like it, smells like it, you don't need them to taste it to know it's not a chocolate sundae. Yes, I always say, people don't overreach, don't push the limit, don't, offend the jury, because if you offend the jury, whether you're on the plaintiff's or defense side, you're going to feel it.
Thanks, Jeff. Jurors are smart, and juries collectively are smart too. But let me take the perspective a different way. And let me ask both you and the defense attorneys, is there enough being done to personalize defendants, to make them likable and empathetic to the eyes of prospective jurors? Let's ask everybody that question.
Well, that's an important issue, and Professor Beer had commented on, the plaintiff coming in, and as a widow and is very sympathetic. And then who's your defendant? Do you have a large business? Is it a large construction company? Is it a real estate developer that may be less sympathetic? Well, my experience is that even wealthy business owners have a story and often have a very interesting and compelling rise to the top story that you can tell when you're basically bringing out that witness for the first time on direct. And they then become people. And, I'll give you a real life example. We do a lot of defense work for McDonald's, and McDonald's is a large corporation. We know that they've been hit by nuclear verdicts over the years. The common McDonald's case is typically a slip and fall, and you see it all the time. McDonald's is named as a defendant. Well, it's not McDonald's who's operating the store. It's generally somebody who scraped up a few pennies from their family for their first franchise and started out with nothing and built a business. And some of them may have 10, 12 franchises at the point when you're defending them, but they started from somewhere. And it's a compelling story. And if you scratch the surface with them, and I'm not just, you're not going to get that at a deposition. The plaintiff's attorney is probably not going to ask them their full history about how they started their business. But as a defense lawyer, you need to know that. You need to get that from them so that you can personalize them before a jury so that they are also sympathetic and realize that they're real people being presented.
Thank you. That's a great insight, because people always empathize and relate to other people and other people's stories, and people like to hear stories. So, Professor Beer, is this a way to level the playing field between the plaintiffs who seem to have a little bit more organization and a little bit more, they've started a little bit earlier, and the defense that sometimes, just doesn't seem to, be able to put the same amount of resources into it because of any number of constraints?
Well, first of all, I want to totally agree with Jeff's comments. One of the things, speaking on behalf of the industry, again, the people on this panel are much more on the front lines. So I'm basically from a board or executive management perspective, looking at massive data. But there's no doubt that the better run insurance companies and the companies that are more successful recognize that there isn't one mode. There has to be a number of techniques to be used. But one of the things that has come out, and people may cringe at data, big data analysis and predictive analytics, but clearly one of the things that's come out is exactly what Jeff has said. And that's why I brought it up. If the key defense witness is that scientist, God help it, imagine if it was an actuary, and having to force people to listen to someone like that, as opposed to, as was suggested, not McDonald's, but the manager of the store, the individual, and personalize that. The data clearly shows that the more the jury feels a personal connection with the individual who's involved rather than some corporate entity, there's always a much more beneficial and correlative effect. So I couldn't agree more with that particular issue. The mistake we all make is we categorize it as, quote, the insurance industry. Everyone on this panel knows there are good and bad, skilled and inexperienced professionals. I think the insurance industry is One of the things I always like to talk, I love talking to claims professionals. I think a lot of companies make a terrible mistake. I know there's a lot of claims professionals on this panel and in this audience. I strongly suggest that the better companies have a connection to the claims department. Everyone on this call would be shocked to hear how seldom claims professionals are brought in front of executive management or brought in front of boards, because they don't understand this is where financial conditions of companies are determined. The people who are on this panel help determine that. And yet it's far too distant. So the more the insurance industry can understand that, the more insurance industry that it isn't one size fits all. And I think the first step in that is related to your question. Rather than criticize the reptile theory, recognize that, yes, emotion plays an important role, and utilize that on the defense side as well as the plaintiff side.
Thank you. Thank you, Professor. That's a great insight. One follow-up question. Why is it that if insurance companies are in the business of handling claims, why is it that the claims function is so disconnected from what goes on up top? How can that be? It almost seems like an oxymoron or a misnomer.
I think part of the reason is that the claim industry has generated a lot of highly skilled, technically oriented people. I mean, all you have to do is step back. Many of us can probably think of insurance companies that are run by underwriters and brokers, people persons, etc. But in fact, I couldn't agree more. The critical decisions are made by people on the front line. It's grossly underestimated, the effect of claims. Conversely, the better companies are very much aware of those claims people. So I can't answer that age-old question. Apparently there's a stereotype and many people buy into it. Again, speaking as an actuary, there are stereotypes and sometimes they're richly earned. But I think the issue is the presumption is that claims people, go out and settle claims. That's what they do, as opposed to actually contribute to the financial well-being of the company. A great company can show how its financial results are related to every single individual in the company. I think, unfortunately, many people have not focused enough on the claim side. That's personal opinion.
I appreciate that. Thank you very much. Yeah.
Tom, just to piggyback that, I mean, in any insurance company, claims is a back-end operation. Underwriting is the profit center. So just like in any company, the profit center gets more attention. The profit center is typically where they pull the top executives out of. So, claims doesn't always have a voice because, again, we're the guys who are spending the money, as versus the guys who are making the money who tend to get the most attention. But as Professor Beard noted, I mean, it's certainly important to listen to claims because we're able to identify the trends that are affecting the company and be able to kind of add strategies, kind of like we're talking about today, that could be helpful in preventing some of those trends from getting out of control.
Thanks, Anthony. Let me move to another topic, and we'll go down memory lane a little bit. We remember when, a starter house was $100,000 and you could buy a mansion for $500,000. Well, now you got starter houses that are $1 million. And back in the day, as has been mentioned, a bulging disc was $50,000. Maybe a herniated disc was $100,000. Now you've got herniated discs, $1 million plus. And if a discectomy is involved or a fusion or some other surgery, it's much higher. Are damages, verdicts, are all of that, are they like home prices that just never seem to go down? Let's start with our defense panel. We'll go to claims. We'll go to everybody can weigh in on this one.
I think that for the most part, that they really don't head down. As we mentioned, if there's a specific event going on where people are a little tougher and somebody's giving them something that's false, they're going to be punished for it. But I don't think the trend is going to go down. And something else that I was just thinking about when Jeff Block spoke earlier about when you guys evaluate your files, and we spend an inordinate amount of time on our roundtables. We roundtable every case from a $15 case to a $15 million case in our office. And it's time that we spend, and we don't bill for it, to get many senior people's opinions on a file. And we're very proud of our ability to evaluate these files, and it's worked very well for 20 years in getting things resolved and predicting verdicts. And where cases do go to verdicts, and not because of either plaintiff's counsel's, expectations or the carrier's expectations, the verdict ranges that we've predicted have been very accurate. So I know that was a long answer to your original question, Tom, but I don't see them going down too much. I think every now and then you have a issue or a factor that gets us on a specific case.
Let me ask Jeff Block, the quote unquote problem. Do you see anything going down, or is it just going to keep on going, just like gas prices? Used to be 50 cents, then $1. And now if you had $1 gas, you'd have a line around 3 blocks to get that $1 gas. What do you see, Jeff Block?
I don't think anything's going down. I think things will either remain the same for a period of time, they'll plateau, spike up, they'll plateau again and spike up. You might have a couple of dips in between, but for the most part, you could draw a trajectory, it's going to be upward.
You think that the political climate in the 80s and 90s, there was a political climate of anti plaintiff, anti litigation, National Association of Manufacturers and a lot of other groups lobbied very, very strongly for caps and demonizing people suing. Do you think that is something that's going to happen if, let's say the political tide turns and maybe the Republican Party gets back into Congress and maybe into the White House?
The reason that we have seatbelts in cars is because of lawsuits, right? The reason we have guards on power saws is because of lawsuits. The reason that construction workers are wearing harnesses and hard hats are because of lawsuits. So we're out there, we would like to see, injuries and accidents go down. Very good, Jeff. But at the end of the day, we're there to change societal's behavior. Society is acting in one way which is inconsistent. If you're only looking towards the bottom line, the manufacturer, the owner of the project will insist upon work being done as quickly as possible without any safety. And lives are important.
Thank you. There was a question that somebody had asked before. And so let me ask you, Jeff, because you would be a person who would have some experience and some knowledge. What effect does litigation funding enter into the whole concept of social inflation, runaway verdicts, and nuclear verdicts?
Well, I'm guessing that the point of this litigation funding is to allow claimants who otherwise cannot afford to go through the process of litigation to survive the time it takes for the case to be litigated and or pay for the surgical procedures if they're needed. There are times when a carrier might turn around and say, I can wait it out, but your client cannot. And it's the litigation funding can serve a legitimate purpose at that point. I think there's also an overuse of it, and it's kind of like the heroin. Once the client starts taking it, it becomes addictive, and they want more and more and more. And the rates are absolutely, ridiculous. Someone's paying 25, 30, 40, 50% a year, and they don't call it usurious because of the fact that it's not a loan. It's there's a risk that they won't get repaid, but the reality is, in many of our cases, we've never not paid, we've never defaulted on a funding company on behalf of one of our clients ever. I don't think there's very much risk at all.
Thank you. Ernie, let me ask you this question because you have a wide perspective on this. Do you see damages leveling off or going up continuously from this point, or is it just?
I think I think the damages are somewhat plateaued, and I think they're going to continue to rise, but I don't think they're going to rise at a dramatic level. I mean, I think there's some offset to that, people understanding that certain things have certain costs. So I think there's going to be a rise consistent with inflation, cost of living, but I see it as a gradual rise, not a dramatic rise.
Okay, thank you. Let's move to a different area and let's talk about what are some of the solutions to social inflation, runaway verdicts, nuclear verdicts. Let's talk about what can be done and how we can work together to try and move the process forward and not just talk about what it is. We are very fortunate to have Jeff Miller on the panel. He's a renowned negotiator and mediator. In fact, Pillinger Miller Tarallo, during the year of the pandemic, 2020, resolved almost 40% more cases than the year before, many of them through mediation. And we're also very, very fortunate to have Jeff Block, who is also renowned as a negotiator and a mediator and skillfully representing his clients. So I have two of the best here, and I want to ask everybody on this. Does the focus on nuclear verdicts obscure and distract from, resolving cases, setting reserves, valuing cases, and moving forward in a positive direction to try and make sure that cases are managed so that they don't end up blowing up? Let me start with Jeff Miller first. Jeff?
I think that what's important here is that is just another factor in the whole circle of things that we're managing in regards to the risk that has to be considered in negotiating and evaluating the case. We've done countless, as you mentioned, mediations during this pandemic and settled an obscene amount of cases, both through mediations and also, and don't forget, the old school pick up the phone and settle the case still works. It happens. Jeff Block and I have settled cases over the phone without mediators. There are times that we need the assistance of a mediator for different reasons in helping us manage our various clients' expectations. But I think it's a factor that has to be considered. And something that we haven't mentioned today is you can even settle during trial. During the trial, many of these cases settle. So it's not like the line is drawn and you have to take that verdict. It's managing the risk on both sides that works. And more often than not, if you're both prepared and reasonable, the case is going to resolve.
Thanks, Jeff. Let me ask Jeff Block from the opposite perspective. Does this drumbeat of noise about nuclear verdicts and social inflation, is that really a distraction from resolving cases and making it sometimes harder to resolve cases?
I would think not. I agree with what Jeff Miller just said. We're in the risk management business. Our business is to demonstrate the risk and show our court adversaries the risk. And they're in the business of understanding it, reviewing it, analyzing it, and coming back with their own theory, if that's the case, or show us why our philosophy is wrong. But whether what a jury can or will do, none of us know. None of us know what the 6 people in that box are going to do. So the only good case for risk management is a case that is resolved. And I was speaking to Mark Pillinger last week at an event, and Mark said to me, if I took 10 of your cases and you took 10 of my cases, and we analyzed those cases separately and apart from each other, and then came back to each other with our evaluations, we would be within about 10 to 15% of each other's evaluations on every case. I think he's correct. Take out the nonsense. Like, the good news is when I have Jeff Miller on the case or Mark Pillinger on the case, they have credibility. And credibility to a plaintiff, when your adversary is a believable person and a person of their word, you trust them. And therefore, you'll give them the true value of the case. Like when Jeff says to me, what do you really need? I'm going to tell him. When Anthony says to me, what do you really need? I'm going to tell him. If someone else that I don't know or has a poor reputation asks me that, I'm going to give them an inflated value. So it's really about, people on your side of the fence establishing good relationships and being true to themselves. If you communicate with your adversary and you're open and honest and you do what you say you're going to do, people will trust you, and whether you're a tough negotiator or a poor negotiator, as long as you're open and honest, people will learn to believe you and know that you're being true, and you'll get things done.
That's a great answer, some great insights, because of course, in this business, as in every business, it's about relationships. It's about how you deal with people, how you treat people, and how you expect to get treated in return. Anthony, from the claims perspective, do you think more focus has to be on reserving cases, valuing cases, rather than the noise of, trying to get every case into a posture where we make 1,000 motions and try and beat the plaintiff into submission with a shopping cart full of paper?
Yeah, I mean, I think, and one of the gentlemen already talked about is I think you really have to stick to your claim fundamentals when you're working on a claim. You have to, properly investigate a claim, from a liability and damages perspective, and you have to put proper reserves on the file based upon that analysis. And kind of like Jeff Block said, you have to, adequately and fairly do that. And, everything else becomes noise. You have to kind of stick to your fundamentals, look at what you really need, investigate your claim, properly price your claim. And then when you talk to someone like a Jeff Block, you have to negotiate in earnest, and try to be fair with him. And in most situations, you're going to get a solution to your case. But, don't get distracted by the noise. That's probably the best thing I want people to remember from a claims point of view. Stick to your fundamentals, properly evaluate your case, do the things as you normally do.
Yeah, I
Great
think
insight. Yes, Jeff.
that's a great comment. And just from your global question, Tom, I think that, everyone on this panel, when we analyze a case, we analyze the case, right? We don't look at societal impact and sociology and, overarching economics. We look at the case and the facts and, potential exposure and all the risks associated with the case at that moment, at that time. And that's how we assess value of cases. But Anthony, something you said is actually triggers a great segue to the next question from the participants. And it's from the defense side, what is the impact of insurance company authority on being able to effectively and timely settle a case? So from your perspective, we'd love to hear the answer. And then from the defense attorneys, probably a good comment on settlement authority.
Yeah, I think, Jeff Block would love to chime in on this, and I'd love to hear what he has to say. But I'm sure from his side, one of the most frustrating things you have is to, have the person that shows up at the mediation have limited authority or not having access to the people that have the authority. I think insurance companies have to trust the frontline people. Listen, if you go into a mediation, the case is worth $1 million. Listen, they should have $1 million, and obviously the expectation is that they resolve the case for the value that they want. Or if your adversary is obstinate, then the case doesn't get resolved. But I think people do need to be given the tools to do their job. So if you're on the front lines and you're negotiating the case, and the case is worth X, you have to have X.
Anthony, that was a very good point. And we also know that reserves are sticky upwards, correct?
Well, they are. That kind of ties back to what we're talking about. Because the biggest driver to most of the cases we have, Jeff, becomes the economics of the case, right? So once you start blackboarding things, medical bills cost more. People are making higher wages. There's a higher minimum wage. So, everything from a damages point of view is like a tick higher, not because of social inflation, but actual inflation. So, we have to kind of keep that in mind when we're evaluating our cases. So, yes, reserves are going to tick up a bit because of those issues, but we're all aware of that. So no one is surprised by that.
Yeah, and the work expectancy and the life expectancy tables, those aren't going down, those are going up. So we have to react to those as defendants when evaluating economic loss. I wanted to come out because we were talking a lot about mediation and alternative dispute resolution, which, we all, do a great job on this panel and an effective job. I think one of the issues that I've seen throughout my career, one of the sticking points and problems in resolving a case is when you have multiple defendants, for example, on a labor law case, and the co-defendants can't agree on even the value of the case on the side, forgetting apportionment for a minute. So what I like to do is reach out to all co-defendants on my cases. Somebody has a subcontractor, the employer might be in the case, the GC, whoever, and get their perspective on what they think, regardless of what they think their client's apportioned value or fault is, what a jury might come back with as a percentage. What do you think the case is worth? Now, if we are, 200% apart and we can't agree, how are we going to ever settle the case with the plaintiff? But by and large, if you communicate, and Jeff Block had mentioned this, with your co-defendants who are adversaries as well, you're going to find some kind of common ground in what the value of the case is 9 times out of 10. So then you go to mediation and you've already overcome a huge obstacle. And that is critical to getting to the point where you can negotiate directly with somebody like Jeff Block. And okay, now you're going to butt heads on percentages, but there's always the option of, okay, we all think this case is worth $3 million. We could figure out how to fund it later. Let's get rid of Jeff before this becomes a $10 million verdict and resolve it amongst ourselves after the fact. I don't see enough of that. And that's really important.
Let me just,
That's
Great
important.
point, Jeff. Great point, Jeff.
let me ask Professor Beer a question here. You've told us that there seems to be a vast divide between the executive suit and the claims function in insurance companies. Does the executive suit, do they take into effect or account for resolution of cases, settling of cases? I mean, obviously resolutions are what it's all about. Insurance companies are in the business of settling claims. Do they follow the trends and make sure that there's an aggressive approach to settling cases, which is really the next question. Are insurance companies helping create runaway and nuclear verdicts by failing to aggressively settle cases?
Well, I think, first of all, the answer to that question is the answers are all over the lot. The better companies are looking at those numbers. Don't forget, I thought Anthony made some great points about there are some companies that simply look at claims paid. The closest they get to the claims department is looking at the claims paid column in the actuarial report. I mean, it's sad, and I don't mean to be disrespectful, but they just don't appreciate what's going on in the claims area. And I mentioned in my opening comments, they think that by making sure that loss costs are built into prices, that they've done their job, when in fact, I think understanding the root causes are important. So to answer your question, the better companies most certainly are looking at the individual claims and looking at what drives a lot of those particular issues. Obviously, a CEO is not going to be able to pour over, as Jeff said, in a roundtable discussion on claims, but there are a number of insurance companies I know of where senior managers sit in on the claims discussions. Good actuaries and good underwriters can learn a lot from about the business by understanding what the claims individuals are doing. So from that perspective, I think it's important that insurance companies, the insurance industry in general, begins to understand better what those issues are. God, if I'm looking at Lemonade here, the fact that nuclear verdicts and not just nuclear verdicts, by the way, one of the points I wanted to make before we close is that, we're talking about the $1 billion commercial auto claim in Texas, but I am personally convinced that has a gravitational pull. And those $75,000 claims of 5 years ago are now settling for $250,000. Because frankly, I think the plaintiff's bar has done a good job of advertising larger and larger claims. So I think that's one of the issues where the industry simply can't be whipsawed based upon what the outcomes are. They have to take a more proactive approach. And I think one of the key issues is to get claims issues and claims professionals much more readily understandable in the C-suite.
Thanks, Professor. Let me ask my defense attorneys and Jeff Block and Anthony too. Do you think insurance companies should be more aggressive and can be more aggressive in resolving cases as a way of solving this social inflation, runaway verdict, and nuclear verdicts? Is that one of the solutions that's the easiest solution, which is aggressively settle cases, value cases, move cases? Let me start with Jeff Miller. Jeff, you've helped train mediators for the Office of Court Administration on how to mediate personal injury cases that are now going to be mediated under the new court rules. You think that that will help resolve cases more?
I think that the courts are really focused on trying to help move cases again. The pandemic certainly put a clog for a moment. That's hopefully getting cleared up right now. But the courts are serious about their own ADR mediation programs, and it's a big initiative. And I do believe that there's going to be more and more time spent on these mediation sessions within the court. Unfortunately, based upon lack of resources and the budgets and that the courts face, this is no knock on the courts because they're really making the effort. But based upon that, sometimes the private mediation services just have the time, especially because you're paying them, to take that time and sit on a case for 3 to 4 hours with, one of the mediators at the services versus a judge who may have 20 cases that day that isn't able to give you as much time.
Thanks, Anthony. You think there's room for more aggressiveness in resolving cases and using that as a way to try and find a solution to social inflation and the whole concept of damages on the rise?
Absolutely, because the key is kind of like Jeff Block mentioned, if we open the communication, we start talking about cases, putting fair values on cases, it's going to help us all. And then one thing that we really haven't talked about is that if you start trying all these multi-party cases, not only does it take an extended amount of time, it takes a lot of money on both sides. Both sides are spending money for experts, and then not to mention their own lawyers. So you have that whole issue as well. So trials are very expensive and they're very time consuming. So
And
to
risky.
and of course risky. So to the extent that we could spend more time looking at the case, evaluating the case, talking to people, it's going to help, because to the extent that you can resolve more cases and try less of them, you avoid nuclear verdicts by not having the case go to trial at all.
Jeff Schulman, your perspective?
We have a question here.
Oh, great. Terrific.
So, we're running out of time, so I'd like to address this to the panel. It says,
Sure.
how can the insurance industry combat those large verdicts being publicized? So I'll just say from, if you're at the large verdict stage, it's too late. It's going to get publicized. So the best way is to try and get it settled. And if you can with a confidentiality agreement, fantastic. I've generally never had a plaintiff's attorney, if I've settled the case for the right number, refuse to sign a confidentiality agreement. Jeff Block, you may have a different opinion on that, but generally I've seen, plaintiff's attorneys have negotiated very high figures with, and they've agreed that, that they're okay with that confidentiality.
It's all, Jeff, it's all in the ask. If Jeff Miller asks me, the answer is whatever you want. I'm never going to turn around and step on his toes, because at the end of the day, I need Jeff Miller or the Jeff Millers of this world tomorrow. So if he asks me for a favor, the answer is yes, before I even ask what the question is.
And likewise, we need Jeff and his firm. And the truth is, we've had cases where plaintiff did want to publicize and our client didn't. And we came to a resolution where the plaintiff publicized a significant verdict, got their press, but didn't have our client's name all over it.
And I also think it goes back to communication. it's not something you want to settle the case and then, 2 weeks later after the release gets, sent and mailed out, call Jeff Block and say, oh, by the way, my client wants confidentiality. I probably should mention that, during negotiations at some point.
I would think so.
To get back to the idea of settling cases aggressively, I would substitute aggressively for realistically. And I think that, when you look at a case early on, you put a realistic number and you have a realistic strategy, and you don't try to show that you're like a real tough guy, assume that, but you're realistic. So there's no surprises. Nobody wants surprises. Insurance carriers, adjusters, nobody wants surprises. So you don't go into a thing and say, hey, this case is a $20,000 case. And then, hey, we're going to mediation. I need $1.5 million. So, early realistic assessment of the case and instead of lowballing it, I think is important. And I also think it's important to understand the definition of a nuclear verdict, because if you have I have cases where, people have fallen 30, 40 feet through a roof and they've broken pretty much everything in their body. And when you put all the numbers together, that's a $5 million case. So if you get a $5.5 million verdict, that's not a nuclear verdict for that case. I'd rather deal with that case if it's, and if there's no surprise there, than deal with a case where you have a case you think is worth 25,000 and you just got hit for $1.2 million. I mean, that's a nuclear verdict in a lot of ways. But
That's a great insight, Ernie.
Yeah.
I think if you look at what, realistically, what is a median verdict in a case, and you work out a settlement strategy accordingly, you're going to be in pretty good stead.
Excellent insight, because one of the things that comes again and again is the best case is a settled case. Nobody likes surprises, as you say. Nobody wants the $25,000 case to be a $2 million case. And if the case is evaluated properly, if it is reserved properly, and if communication takes place properly, then there's always a chance to resolve a case. Because quite honestly, as Jeff Miller says time and time again, we're in the resolution business. And cases are not like fine wine. They don't get better with age. The only thing that happens with an old case is it's going to be more expensive to resolve. And nobody wants to get a phone call that says, you have the oldest cases on my docket. Everybody wants cases to move. And that's one of the ways that I think that the insurance companies and the industry itself and the plaintiffs bar can help everybody by realistically evaluating cases and settling cases. We're winding up to the tail end of our discussion. Are there any questions that are left outstanding there, Jeff Shulman?
There was one that is about safety.
Okay.
And it says, let me see if I can find it. It was up there. I don't know if it was removed. No, okay. It's asked to talk about safety questions and how defense can address them in depositions, pleadings, and trial. And I guess in tying that, we should tie it into the overall avoiding a nuclear verdict, right? Ernie, you want to try and tackle that one to start?
Safety?
Yes. How you would address safety questions as a defendant's attorney.
Well, I'm not quite sure the focus of that in terms of, maybe somebody can give me their interpretation of what they mean by safety.
I think they mean the failure of safety. In other words, if there's been a failed safety issue, someone didn't do something that they should have done, maybe, some overt omission or negligence. How do you deal with that in the context of, a case?
Yeah, Ernie, I think they're, driving at, when you're defending, especially a construction case, how can, include your safety plan, toolbox tools, et cetera, how can mixing that into your defense, help you in terms of avoiding a nuclear verdict?
Yeah, look, you have to recognize that if you have an issue with, maybe there wasn't a proper safety meeting, or there was a procedure that wasn't followed, you have to recognize that early, and then you have to focus on some other areas. Maybe you focus on causation, maybe you focus on damages, maybe you focus on some other, unforeseeable circumstances. There's no point in belaboring a dead horse on a case. If it's a legitimate argument and there was a failure in that area, then look at the other areas there and see where you can go with that. but, just don't keep flogging the dead horse.
Right, and I think that you want to avoid a situation where even though a plaintiff may not be asking for punitive damages, that the verdict might be punitive if safety violations were so egregious. And to Anthony's point, if you have a client that they have a site safety plan, they have weekly tailboard meetings or safety meetings, toolbox talks, whatever you want to call it, and they can document that, and they provide safety devices that are readily accessible. Well, in this particular case, did the plaintiff fail to wear a harness and fall from, a ladder or not tie off the ladder? Okay, yeah, there's a violation there, but we really, as a custom and practice, do everything we can to ensure that we don't just want to do the job quickly, as I've heard, plaintiffs so often, say time is the essence, highlighting that aspect of the job, but that safety is a number one priority, and to emphasize that.
Thanks, Jeff. Well, I think we're winding down. It's just about 3:30. And so I'd like to bring our webinar to a close. And I'd first like to thank our panel for your time today and for your effort. So appreciated to have this great panel here and all of the insights and the discussion. I'd like to, of course, thank all the attendees for taking time out of your day and gracing us with your presence and giving us the benefit of your attention. I'd also like to once again thank St. John's University. That's Dean Sharp and Dean Brandon Schweitzer. We have deep ties to St. John's, and we love being a partner with St. John's on these conference series webinars. And I'd also like to thank the people who help us on the back end. That's Larry Pastel from St. John's and Joe Levine and Rob Stewart from CC&G, our media partners who help us put this whole thing together and work with us on making sure that everything goes off smoothly. And one of the ways that Pillinger Miller Tarallo provides you with extra value is we are here to serve as an informational resource for you. So if the attendees have questions, if you have something that you think of that comes up afterwards, you can certainly ask us a question. We're always here to serve as your trusted advisor and to answer the questions for you. And if we can give you some insight, we'll be happy to do that. And we're also happy to serve you in any way we can. So on behalf of Pillinger Miller Tarallo, all our panelists, St. John's, and myself, I'd like to thank everyone for being a part of this webinar. Thank you so much once again.
Thanks, everybody.
Thank you. This is great.
Have a great day. Jeff,
Thanks,
I'll call you to
everyone.
settle a case. I'll call you tomorrow to settle a case.
Phone's always open, buddy.
You know it.